All right. Good afternoon, everybody. My name is Peter Hanna. I'm a managing partner with the law firm of Hopler, Wilms, and Hanna, and we're happy to bring to you unemployment benefits in North Carolina, what employees and employers need to know during these unprecedented times. This webinar is going to be for the purpose of answering some of the basic questions about changes that have occurred over the last 3 months to the unemployment laws. Just a little bit of background about the law firm. Here at Hopler, Wilms, and Hanna, we've been practicing in the class of unemployment benefit law here in the state of North Carolina. We have about 40 years of experience. Our firm is here headquartered in Durham, North Carolina, with 2 offices located in Durham. We have offices in Raleigh and Sanford, North Carolina as well. And again, we, as attorneys who practice both as representing claimants and employers, have a unique perspective regarding how these changes are going to impact clients moving forward. And so, again, this webinar has really been tailored to address some of those questions that we've been seeing from our clients, whether that's the employee or the employer moving forward. We believe, some good information to present to you all as we continue to move forward through this state of emergency. Just again, another plug about myself. Before going into private practice, I had the honor of being a hearing officer with the Division of Employment Security, what was at that time the Employment Security Commission. So again, I provide a unique perspective about not only unemployment law, but what these judges are looking at in unemployment hearings. I had the honor of being basically trained and supervised by Miss Regina Graham, who's the Deputy Chief Appeals Referee for the the Division of Employment Security's Department of Appeals. And she's joining with us today. And I want to give Regina the opportunity to introduce herself and talk about her prior experiences and how she's gotten here today. Regina?
Good afternoon. Again, my name is Regina Graham, and I've been with the division for over 11 years. I spent my first 6 years as an appeals referee. And then I've been Deputy Chief Appeals Referee for over 5. Prior to attending law school, I actually worked in retail management, so I have a business background, so to speak. And so I do have experiences as far as managing other folks in the private sector. Additionally, I'm also considered a subject matter expert in appeals and a subject matter expert in our new benefits system.
And again, that is why we're excited to have Deputy Chief Appeals Referee Regina Graham here on this webinar today, again, providing us with clear information about what's going on. And again, as she stated, she's a subject matter expert, and we could not ask for a better guest to join us today. So with that stated, we're going to go ahead and begin by getting right into it and talking about the background of what unemployment insurance benefits are and more or less how we've gotten to this point of the COVID-19 crisis. You know, prior to March of 2020, ultimately, when we understand unemployment insurance benefits, we're talking about employers paying into an unemployment trust here in the state of North Carolina. When employees go out and earn wages, employers are having to pay state and federal taxes on those wages that the employee earns. And those taxes are then used to fund unemployment insurance benefits, so that when an individual files for claims, they are taking money from that pot of this trust that we utilize here in the state. Here in North Carolina, for an individual to qualify for unemployment benefits and to be eligible for those benefits, they have to meet some basic criteria. Those criteria that you've been unemployed due to no fault of your own. That means you didn't resign from employment unless there was good cause attributable, and we'll talk about that later on. That you're monetarily eligible for unemployment benefits, and that you're able and available to actively seek work in the labor market. And you know, Regina, prior to the COVID-19, how many when they do a weekly certification, the claimant, how often are they having to look for a job on a weekly basis?
They have to have 3 contacts per week.
All right, very good. And so again, prior to COVID-19, the maximum benefit that you could receive from the state of North Carolina on a weekly basis was $350. And again, that's an interesting formula that looks at what you were earning at your prior employment, and that's how they make the determination as to what you're earning per week. And at the time of this crisis in March of 2019, this was capped at 12 weeks that you could receive benefits during this period. And we'll talk again about extensions and everything like that later on. What if you're found disqualified for benefits, or if you're an employer and you find that an individual has qualified for benefits and your tax rate goes up? What can you do? The state's constitution provides for due process of law and allows for these informal proceedings to be held before a licensed attorney, also known as an appeals referee, to determine, based on the evidence, whether you qualify or should be disqualified for benefits, or as an employer, whether the former employee should qualify for those benefits. And these appeals referees are finders of fact, and they determine, based on the information provided and the facts surrounding the separation, whether those benefits should be issued. And again, that's a very simplistic discussion point of what happens in these hearings. We always recommend that either the employer or the employee be represented by counsel, because there are some formalities to what we consider to be an informal proceeding. Both the employer and the former employee have a financial stake in this unemployment hearing. Obviously, if the claimant's found qualified for benefits, they'll receive up to 12 weeks of benefits. The employer, if they are unsuccessful or if the claimant's found qualified, they could see an increase in tax rate or have to pay out those benefits. Anything you want to add to that, Regina?
Nope, it's absolutely accurate right there.
Very good. So now that's the basic background of how we got what we had in the system before this. Now, obviously, there's been some substantial changes. That started on March 17, 2020, when the governor executed Executive Order number 118. And the governor came in and basically provided this order that established that we understand that folks are going to be laid off or furloughed, and they provided that separation from employment or having hours reduced would allow you to qualify for benefits. And if you were prevented from working due to a medical condition caused by COVID-19, or if you cannot work due to CDC measures, there was either a quarantine or a stay-at-home order that impacted your ability to work during that period of time. And again, when we think about this period of time, it's the period in which the state is under a state of crisis. It's the period where there is an emergency protocol in place. And so the governor also waived the 1 week waiting period for unemployment benefits to be suspended. You typically had to wait 1 week to receive benefits. That was waived. And you're not, more importantly, required to file in your weekly certification that you're looking for other jobs. They understand that eventually you may be able to get back to your new place of or your old place of employment, and that the stay-at-home order or the pandemic, they're waiting on that to end before you can come back to work. If you work, for instance, at a gym, they understand that you may not be employed currently, and obviously things have changed in the last 24 hours, but this was perfectly set up for you to receive those unemployment benefits, and you're not having to look for work at another gym or outside the industry. So that was the big change with regard to the executive order, and this was followed up by the CARES Act. And the CARES Act was a federal law that was passed on March 27, 2020, and this had major impacts to unemployment benefits. But before I continue on in discussing the CARES Act, anything, Regina, that you want to add with regard to the executive order and its changes?
No, I just want to remind everybody that it is temporary. So these rules our regular rules will go back into place eventually. You'll be required to do a work search. So just be mindful of that. This is a temporary order.
All right. So again, and throughout the course of this period of time, these last 3 months, the governor has provided several executive orders, and that has been a key point, is that this is only during the state of crisis and will end eventually. And we anticipate, we don't know when that will be, that one certainly would not want to make any quantifiable statements on that, but again, something to keep in mind. So again, coming back to the CARES Act, again, this was a federal law passed on March 27, 2020. one of the big discussion points, or one of the big impacts on unemployment benefits, was that folks who filed for state unemployment could receive, on top of the benefits that they were receiving from the state, an additional $600 per week, which would be issued to North Carolina residents when they filed for unemployment benefits. And the supplement was to cover the period of April 4th, 2020 through July 31st, 2020. And it's paid on top of your weekly benefits, as we discussed, and it does not reduce or replace your weekly benefits. Also, in addition to, and again, that's under the PEUC program, and we'll talk more about that program later on. In addition to this $600 increased amount for unemployed individuals in the state of North Carolina, the CARES Act also provided that self-employed workers, also famously known as gig workers, could also receive a unemployment kick from the state of North Carolina and would be eligible to receive those benefits. And again, one of the big points that the Division of Employment Security wanted to make known to individuals was that you may initially be turned down for state benefits, but you'd be moved over to the Federal Pandemic Unemployment Assistance Program, the PUA program, and those employees must certify weekly that they're still unemployed. Also, in addition to that, church employees who were typically exempt from unemployment taxes are now eligible to apply for benefits and receive this added benefit. Regina, anything to add to that with regard to these ICs and self-employed workers receiving those benefits?
No, just with the PUA program, it is a big expansion program, and it is federally funded. This is not a state program. It is actually a federally funded program. Yes, and it has a broad scope. So it affects everybody. Everybody in North Carolina potentially could move on to that program if they are not eligible for state benefits.
So I know that many of you, again, who may be joining us today, who are considered, again, gig workers or self-employed workers who are independent contractors, probably have seen that there was some delay in receiving those benefits. The Division of Employment Security, along with the governor's office, really put it out there that it was clear that beginning April 25th, 2020, those benefits would be available to those individuals who were filing under this program. And again, the division has worked exhaustively to make sure that those benefits are available to state residents who qualify under this. In addition to the PUA program, again, under the PEUC program, individuals who were receiving initial 12 weeks of unemployment benefits from the state of North Carolina could also apply for and receive 13 weeks of additional benefits through this federal CARES Act program for additional unemployment benefits. So again, if you had exceeded your 12 weeks due to the COVID crisis, you would have an additional 13 weeks of additional benefits as long as you file for that. And something when we were preparing for this that I was unaware, Regina, was that folks don't automatically get these benefits. They have to actually purposefully go out and apply for the 13 weeks. Is that correct?
That is correct. The Department of Labor stated that they had to reapply.
And so what Regina has provided is this additional link that provides more information to folks who want to learn more about how they can receive the additional 13 weeks if, for instance, like we said in the initial beginning with regard to a gym worker who was still continuing to have unemployment after 12 weeks, they could continue to receive those 13 weeks of benefits as long as they did not have continuing work available to them. They could file for that. And again, we recommend that you go and check out the website and begin the filing process for those additional 13 weeks.
Let me make a comment on that. You won't see that link until your benefits are exhausted. So if you're already exhausted, you got the link. But if you are still actively receiving benefits and you maybe only have a few more weeks left, that link will appear once you've exhausted. So you cannot pre-apply to the program.
Yeah, thank you for that, Regina. I think that's a really good point. So you can't actively just try to file for it ahead of time. Is that correct?
That is correct.
All right. In addition, Regina, when we were preparing for today's webinar, I was talking to you about some misinformation that people were finding on the internet, and even as an attorney, I was seeing this reported with regard to the PUC. Do part-time or partial filers, individuals who may only have their hours cut, do they qualify for $600 additional or no?
Correct. They do. This is a federal program. The federal program does not differentiate between part-time and full-time employment.
All right. And do they get an extension of that $600, or is that capped at a certain period?
It's the same period. I guess I don't understand the question. It's good through July 31st of this year.
Yeah, thank you. And so they can't get an extension and continue to receive $600, say, after July 31st of this year.
Well, no one can get an extension. This is a federal program. It is scheduled to end. The PUC program is scheduled to end on July 31st.
All right, thank you.
The PUC, that's the extra $600. It's up to Congress whether they're going to extend it.
All right, thank you. And that's a great segue to discuss further, again, this PUC program. You probably heard in media outlets these discussions of PUA and PUC and the PUA acronyms. And again, just to reiterate, those programs talk about how individuals can continue to be available and eligible to receive regular state unemployment benefits during the COVID-19 period. And again, this PUC is set up for individuals to receive benefits from April 4th, 2020 to December 26th, 2020, as long as they qualify for a COVID-19 related separation. And again, in North Carolina, our maximum weekly benefit PUC is $350 a week. That is governed by our state's statutes. So again, that's how it stands at this time. As mentioned by Regina, again, PUA is a federal program for individuals who are unable to work as a result of COVID-19. And while it is governed through the federal program, the state is authorizing as a carrier to issue these benefits. And they are working diligently to get to those points. Now, that's the impacts to the employees. Now, let's talk about what does this mean for a business, a small business, medium-sized business, or a large business here in North Carolina. What happens as a result of these individuals going out due to furlough, due to closure, due to a stay-at-home order, what have you? Under, again, that executive order that we talked about, 118, the governor said that employers would not be held responsible or charged for an employee seeking benefits due to COVID-19 separation. That's incredibly important for small businesses where they're not going to see an increase in tax rate. They're not going to see a bill that says that because this individual was furloughed for benefits because they can't work, you're going to be responsible monetarily in some way. And so really incredibly important. We're going to talk about non-charging in some more extent as we talk about what happens with folks who are now returning back to the workforce after the stay-at-home orders have been lifted, and we are now in this quote-unquote phase 2 of coming back into the workforce. Now, this is a particular topic that it's incredibly important that we have Deputy Chief Appeals Referee Regina Graham on the line today with us to talk about employee filing process. I know that employee filing has been a huge topic of conversation, but as it stands right now, employees can apply online over the phone and do not need an in-person interview to obtain benefits. We have our workforce solutions all through the course of the state. And we have many offices in which individuals could do so. But again, given COVID-19, that's not a reasonable expectation. So the state has worked diligently to provide added resources for phone and online services. And
let me just stop you there. I just want to make sure that we get this accurately. The NC workforce offices and those career centers, they do not file claims. They have computers there that folks can use to file a claim, but they cannot file the claim for that individual.
Thank you, Regina. And so what is the best way for these individuals to apply for and keep tabs with their account?
to file online. It is the fastest and best method. Using a computer is preferable because we do not have a web-based solution. I mean, we don't have a mobile-based solution. So getting onto a computer and filing, we've simplified the creation of an account. You should not have to have contact with us. All you need is your social security number and a valid email address, and you can create an account. And then you answer some questions, and then you file your claim. And it should be that simple. Most people are very successful in it. We can take it over the phone, but you're going to have to call the 888 number then.
And again, we know that the state has really provided additional resources to provide more availability for those who are calling in. Is that correct?
That is correct. We have additional, I think, 1,500 people answering the phones.
Perfect. We've been getting a lot of calls here at our firm about individuals who are trying to fill out their claims, their claim information online, and they're asking about how, what do they choose if they've been separated due to a COVID-19 situation or reduction in hours? What can you tell those folks?
For those folks who have been separated due to COVID, you have two selections. You can have layoff due to COVID, or I think it says coronavirus, or reduced hours due to coronavirus. Those two selections will be a non-charging event to the employer, and then we'll also give you the PUC money for the claimant. If you don't select that, you'll have to go through regular adjudication. Okay.
Now, we had talked about earlier the fact that under the executive order with the governor, he said that we wouldn't have to, claimants wouldn't have to provide weekly certification showing that they're looking for a job out in the labor market. Are they still required to fill out a weekly certification? And if so, why is that important?
You have to fill out a weekly certification every week in order to receive monies. We are not currently pursuing the fact that you have to look for work, but you must fill that out. If you don't fill it out, we don't pay you money that week. It's that simple.
Are there any negatives? And I guess I know this is a softball type question, but the question is, how important is it that the claimant really provide accurate information in their weekly certification about what their wages are for that given week?
It's extremely important that they provide that gross wages when they work and that week that they earned it. The reason why is that we will do what they call cross matches. We're going to ask the employer about wages, and this happens all the time. And if you underreport, you're going to get an overpayment. And then if you overreport, you may not get anything. So it's very accurate that it's very important that everyone is accurate about those weeks that you're working. You report your hours that you work, and then you put your gross wages in. Now, it may reduce your benefit, but that's okay, because eventually we're going to catch you on the overpayment eventually. And that overpayment means that we're going to be sending you billing, and we will, the state is very committed to recovering on that.
Thank you. In order to file a claim, what kind of information does a claimant need to provide that information to the state in order to seek eligibility?
To file a claim, you have to have a valid social security number. You need to have a valid email address that's to get your account created. And then your pay stubs for the last 2 years. And what I want to caution folks is that a lot of folks do work for subsidiaries. So make sure you maybe look at your W-2 form. We have people get tripped up because they don't see their company. And I'll give you a perfect example. There's a big furniture company out in Western North Carolina, and it's called Century Furniture, but they have subsidiaries. So a lot of people didn't realize that Century Furniture has been paying their wages, but so they put in a subsidiary and they hand keyed it in. Well, that creates issues for us because it doesn't match. What you've put in doesn't match what the base wages have been reported. So it just causes some unnecessary delays in getting your claim figured out. It actually requires us to hand look at your claim, where eventually, if it was done correctly to begin with, it's a much more smoother process through.
All right. Thank you for that information, Regina. Regina, we've also been getting a lot of questions about those folks who have to file more or less interstate claims. Maybe they don't have a base period that's fully been in North Carolina. What is the state telling those folks with regard to how these are being processed?
Well, an interstate claim requires us to go to another state and ask for wages. So it's just a little bit delay. There's a special team that I believe handles all of those. But there will be a delay.
Okay. Very good. So let's go to the next. Now, with regard to the indication as to why, what an employer has to provide in terms of information, very important for employers to understand that when somebody files for unemployment benefits here in the state of North Carolina, the employer is going to receive a request for separation information from the DES. And ultimately, that information is seeking, or excuse me, that documentation is seeking information as to why is this individual filing for unemployment benefits? Why did you separate them? And it's incredibly important. And I know we've spoken with some of our clients who are like, we don't know what to provide. And you really want to indicate that if the reason for separation was due to COVID-19, that you're explicitly stating that in the information. In addition, we've also had clients who have been coming up to us and saying, well, it says here I had to turn in the documentation within 10 days, but by the time I got the documentation, the time has expired. What do I do? Regina, what do you tell those folks who have received documentation late? What should they be doing in order to make sure that they are keeping up with the timing issues?
It's my understanding that we have suspended the timing issue right now. We understand that they may have been mailed late or received late by those employers. I would go ahead and maybe fax it back in just to have it on record, but you should not see any problem with benefit charging later on. And of course, it's also important maybe if to report if there really wasn't a COVID separation. That would, we would want to know that too.
Certainly. If obviously somebody was separated in February and you're just getting the documentation and you need to talk about what the reason was why they were separated in February. Another point to bring up is that with those folks, there was a question that was asked is, well, how long does the employer have to make or to provide this information? And again, prior to COVID-19, they had a 10-day timing period in order to provide this information to the state before they were to adjudicate that. Things have obviously changed a little bit. I think the division understands that employers need a little bit more time to file that paperwork. Would that be accurate, Regina?
That's correct. And of course, what I would just be mindful of is that all employers, I believe, have an online account. At least you have a tax account, and we have a team here who can develop a claims account for you. And so if you know that you've laid off your employees, go and look on your account. Those information is going to be there for you to respond to.
And Regina, does the division have necessary resources to provide to employers to help them create accounts or to answer questions about their online account?
Absolutely. We actually have an employer call center that we staff. And it's staffed, I don't know couldn't tell you how many there are there, but they are very well trained and ready to help any employer out there.
Okay.
If you'd like, I can give you that number.
What we're going to do, folks, is that ultimately, when we have what we're going to do, this PowerPoint presentation, is we're going to make this available on our website along with this additional information that that Deputy Chief Appeals Referee Regina is going to provide to us so that employers have those necessary resources to get their online accounts set up or answer any questions that they may have if they are having some issues with those online accounts. And we'll provide that after today's webinar. Now, we are now in this phase 2. Obviously, some important things are happening now. Folks are starting to come back into the workforce, thankfully. Those folks who may have been working at home are now being expected to come back into the office, and they may or may not be given, quote unquote, the option to do so. And so a lot of folks are calling in and asking, well, do I have to come back to work? And businesses are asking, can I make them come back to work? And the state has provided some resources and discussed that there are several factors that the DES will consider as good cause for you to refuse to return back to work if you're a claimant. And employers need to be aware of these as well, but we'll talk about why this may not impact them later on. Ultimately, the issues for which an individual can say, I'm not ready to come back in the workplace, maybe because you've been diagnosed with or have symptoms of COVID-19, you have a high fever, or you are having some type of breathing issues. Maybe some in your household or your family members are providing care for, or you are having to provide care for those individuals who have COVID-19. Maybe you're at high risk of a severe illness from COVID-19. You have a low immune system that puts you at risk for these underlying issues. And again, you have medical documentation to support why you can't come into the workplace. Maybe, as we know, our Wake County schools and all our schools in the state of North Carolina are closed currently, and you have to provide childcare for that individual because you're the person in the household who's responsible for that. And that may be that's obviously a direct result of COVID-19, and the school facility is closed because we are closed under a state of emergency. That is a good reason not to report. Being unable to reach your place of employment because of a stay-at-home order. Refusing a recall to your former employer as an offer of suitable work because the employer isn't set up to more or less protect your needs. And again, that's a very fact-based issue that could be argued. But again, that's one particular point that could be addressed. And reasonably believing that you have a valid degree of risk or that keeps you out of the workplace. Any points to that, Regina?
No, I just want to remind folks about the school. That will change now that schools are closed for the school year. So just something to keep in mind.
Absolutely. And I think that's going to be some of the points that are going to be involved in these appeal hearings. And those will be questions that are going to be asked by the appeals referee as to why the individual, you or the claimant, have refused to come back to work. Also, something to keep in mind for employers is saying, well, a lot of this is very subjective. I don't know how we as an employer can keep up with somebody who believes that they have a high risk of that they don't believe that their health and safety is going to be protected. What happens to us? Do we have to continue to argue these cases and put together, a Supreme Court case? Obviously you want to clarify to the Division of Employment Security what you all are doing to protect your people. But ultimately, in instances where the employer has to deal or sees an employee that can't come to work because of, their own medical issues, ultimately you're going to receive a non-charging event. And again, that's, as we discussed before, a situation where your tax rate won't go up, or you'll be responsible for unemployment benefits because the claimant has the special circumstance that we've discussed. Now, on our end, as a firm, and again, I've been representing employers for about a decade, I would tell my clients, and this is the strong recommendation, that when you're getting back into a situation where you're bringing people back into the workplace and folks are being placed on notice, we think that you should put this in writing. And there's two reasons to that. One, you should always keep things in writing when you talk about your employer-employee relationship. But for many of our small businesses, they've applied for PPP funding, payroll paycheck protection. And we are going to say that if you want to receive forgiveness and an employee is not willing to come back to work, you need to provide to the SBA proof as to the fact that an employee is unwilling to come back to work for whatever reason. And so we are telling our folks, go ahead and put together a non-offer letter telling your folks, hey, it's time for you to come back to work. Do you accept your continuing work available? Yes or no? And again, that's clear evidence to show to the SBA or the Division of Employment Security that we offer the continuing work and it was denied or accepted by the employee. And again, like I said, we want to see that in writing. It's clear, it's unambiguous. And if an individual who's receiving unemployment benefits is unable to or does not wish to return back to work, we are recommending at our firm that the employer notifies the DES via the employer's online portal within 3 days that the offer has been rejected and any other information. Anything to add to that, Regina?
No, I do believe that those online forms are available to the employers. They're actually in the employer portal. They are available to them right now if they want to.
That's a wonderful resource that is being provided by the Division of Employment Security. It really makes it as easy as possible for our small businesses. We know that you guys are dealing with a lot of things that are going on right now, and this is just an added weight on you. So I think the division in providing that additional resource is going to be extremely helpful. Now, again, our firm has had the opportunity to really field a lot of questions from folks over this time period with regard to questions that have been asked about things that are, about their unemployment benefits, a lot of filing questions, or, hey, I need to know more about the federal program. And so we wanted to address some of these frequently asked questions that we've been seeing. Some of this is going to be a rehash of some of the things that Regina and I have discussed today. One of the questions we've been asked is, do I qualify for additional money as a claimant? And again, as we mentioned, under the CARES Act, under the PEUC, people who are eligible for regular state unemployment insurance will receive 12 weeks of benefits, up to 12 weeks of benefits, and then they can file for an additional 13 weeks of benefits on top of that. So you can file for an extension. So I know one individual had asked the question of, well, how long is that? Again, that's 12 weeks and then an additional 13 weeks if you apply. And so a great opportunity for the individuals if they continue to suffer from unemployment as a result. Can I quit my job and still receive benefits? Well, again, it depends on the reason why you're quitting your job. Are you quitting your job based on the points that we addressed before, that you have a medical issue due to COVID-19? Do you have to take care of a child who's suffering from COVID-19 or another family member that's suffering from COVID-19? It's difficult for us to really establish that unless we speak with you. But I will tell you that it is difficult for employees who quit without good cause for them to receive unemployment benefits here in the state of North Carolina. Would you agree with that, Deputy Chief Appeals Referee?
I would agree with that.
Yeah. Will I be charged if a former employee receives benefits? Now, the Department of Commerce, the Division of Employment Security have been directed to not allocate charges to employers' accounts for individuals who are paid benefits for reasons related to COVID-19. Now, if you separate an individual for a reason other than COVID-19 and that individual has not committed misconduct or they haven't quit, you could see benefits or see charges to your unemployment tax rate. When should I file to receive federal benefits? As we discussed before, again, you would have to file separately with regard to the 13 weeks, correct, Regina?
Correct.
But with regard to the $600, how do they file for those $600?
They have to file for you have to file for unemployment regardless.
Okay. Is that automatic?
Is the $600 automatic? You have to be eligible.
Okay.
You have to be on a program.
Okay.
So you can get it through the PUA program too. The PUA program it provides the $600 too.
Okay. When do additional benefits run out? And again, we've kind of harped on this, that you receive up to 12 weeks of benefits. And then after those 12 weeks, as of right now, and we don't know whether the feds are going to extend this, but as of right now, you'll have an additional 13 weeks. After that, you will no longer receive benefits under the PUC program. Is that correct?
That is correct. And then the PUC program expires on July 31st.
Okay, thank you. What happens if an employee refuses to come to work if work is available? And again, this is a question that a lot of small businesses and medium-sized businesses are asking right now as we've entered into phase 2. What are we expecting? And again, employees are allowed to report to DES that employees have not returned to work when the work is available. And once that's reported, the DES will review that information. Regina, anything you would want to add to that with regard to how the state will continue to review these situations?
Your response is accurate. We're taking that information, we're reviewing it, and we will determine eligibility off of that. And you should get a determination off of it. The claimants will, and the employer.
Okay. And turning it over to you, Regina, can an individual, a claimant, file for partial benefits?
Well, I'm not sure I understand the question of partial benefits, but what can happen is that you, if you are reduced, say we're working 40 hours and now you're working 20 hours. And as long as you report those gross wages and they are less than your weekly benefit amount and the amount that you earned, you can receive the PUC. So basically, it's if you're paid $1 of unemployment, you will receive PUC. Okay. Does that answer your question?
Yes, ma'am. Okay. Can I receive benefits if I'm the only employee in the company? To that question, yes, a business owner that's required to pay unemployment benefits, they have a salary, they're paying unemployment insurance taxes, they will be eligible to receive benefits. If you are not paying salary, you're not paying state or federal taxes, you can still qualify for benefits as an independent contractor through the gig program, but that's through the PUA program.
That is correct. And there's very specific information that we will need from that claimant to establish your PUA. And that's all available on our website, like a 1099, pay stubs, tax returns.
And I think, Regina, that comes up to another point and we don't address this really, but for individuals who have questions, specific questions, and they don't have access to an attorney, how does the division really provide resources to that individual to answer some of these specific questions if they're, again, a subcontractor, or what questions they have on unemployment?
Well, we have first of all, I would recommend anybody going to our website, which is des.nc.gov. We have incredible FAQs and tip sheets that provide specific information that a person needs to file a claim or to answer most of your questions. If you go around, just look, if you're not even sure, if you just type into the search engine PUA, a lot of information is going to come up for you. That would be my first recommendation. We do have a phone number for PUA that is addresses specific PUA claimants. I don't think I have that number handy. I can give it. I can give it to you after the fact. Actually, I take that back. It's 866-847-7209. That is a specific phone number for PUA.
Can you give us that number again, Regina?
I'm sorry? Yeah, sure.
Number again?
866-847-7209 is for pandemic unemployment assistance.
And I'm posting that right now. If you'll see at the right hand of your screen, folks, we provide that telephone number for those folks who are who have some questions about that. I'm sorry, Regina, I was cutting you off. Go ahead.
That's okay. Just look on our website. We have a lot of great information. There's tip sheets. In fact, the one I just gave you that number on, it's a 3-page sheet on how to apply, what is PUA, and what are PUA payments. Tells you exactly what you need. And I would, it's on our website, and you can see it on a mobile device. I don't recommend filing a claim through a mobile device, though.
And thank you for clarifying that, because again, your recommendation is to file online through a computer. Is that accurate?
That's correct. You will have less mistakes.
Okay. Regina, can part-time employees continue to file for unemployment benefits, or are they automatically ineligible?
Part-time employee can file right now with the federal. These are all federally funded programs. Absolutely.
Okay. All right. What if I fire an employee for a reason other than COVID-19? How is that treated? And again, we've kind of talked about the fact that there's kind of a different parameter for those folks who have been separated due to COVID-19. If you're separating an individual due to performance, for other reasons, again, that has to be information that you present as an employer to the Division of Employment Security when they ask you for information as to why there's been a separation, and that will be treated under the laws that we've discussed in the earlier part of today's program, about where we are going to be discussing whether the individual qualifies for benefits, have they committed misconduct, have they resigned from employment. So again, that is going to be separate from the discussion point about COVID-19. I know many of you have had questions, specific questions. Folks have had specific questions about maybe their own business or about what they're going through as an employee or former employee and how they're filing for benefits. We want to throw out there that this firm is providing for those claimants, those former employees who are filing for benefits. We are offering consultation fees at $50. And for employers who have questions about documentation, about how they file, or what to do if somebody is not more or less somebody that's either been on their payroll before or anything like that, we're offering a $125 consultation fee. And more likely than not, you'll be speaking to me regarding those particular points. These fees only cover answering questions, but they do not they're not a discussion of representation before a appeals referee in an unemployment hearing. There are separate fees defined for that. That's basically the webinar. We hope that you were able to receive additional information, or at least have received resources to where to get more information. Again, we'll be posting this PowerPoint along with additional information provided by the DES on our website after the webinar is concluded. And we certainly welcome and invite you to come and to contact us if you have additional questions. Regina, anything on behalf of the Division of Employment Security regarding today's meeting or the webinar or unemployment benefits?
Actually, before I conclude, I'm seeing in this screen here a question from an employer, and it says, I have a situation where a couple of my previous employees filed for unemployment benefits. How do I need to respond in this case? You need to respond, because even if you're not the last separating employer, you are considered a base period employer. And to avoid some charging of benefits over there, you need to fill that out and let us know why they're no longer working for you. So you're talking about the charging issues, please make sure it's an employer, please fill out, they're called a 551. Please fill those out and send them back to us. They're very important to your account.
Okay, thank you.
And in regards to today's webinar, I want to thank you, Attorney Hanna, for inviting me. I'm very proud of the state of North Carolina. I'm very proud of the Division of Employment Security and how we've responded to this pandemic. If you need any questions, have any questions, please refer to our website. We have a wealth of information in there, and we also have our 88 number that you can call to.
Okay. Thank you, and we want to thank again Deputy Chief Appeals Referee Graham for making time today to talk to the public and to speak with our law firm about today's issues on unemployment benefits. Incredibly ecstatic to have her on. Before we end, I wanted to address just a couple more questions that we have here, and I'll turn it over to you, Regina. The one question is, are an employee's payments impacted if the employer goes out of business during COVID-19?
No.
And again, that money is coming from a trust. It's not being paid directly by the employer. So whatever happens to the employer status shouldn't impact anything. And
correct.
Then one last question. If an employee has a reduction in pay but not hours, are they eligible for PUA? And again, that question, they
actually they wouldn't even get PUA. They would be regular. They would be regular UI.
Mm-hmm.
So if they wanted to file, I would have them file a claim. But PUA means that you're not qualified for regular unemployment. And if you're still working, that means someone's been paying taxes on you.
Correct. And for Patricia, who asked that question, that's actually there's a more in-depth factual discussion point on that. So we certainly would recommend that you reach out to an attorney with regard to that particular point. But folks, I want to thank you again for attending today's webinar. We hope that, again, you received some good resources. Again, we will post all of this information. We certainly ask everybody to stay safe during these unprecedented times. And again, if you have any questions, reach out to us at 919-244-2019. Again, we'll post that information after the webinar. Thank you again. And again, thank you to Deputy Chief Appeals Referee Graham for your time and attendance today. Thank you.
You're welcome.